Welcome to the Five Stone Buildings webinar programme. We have just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Whilst we are waiting, I shall just remind you of the house rules. Just to remind you that this webinar is being recorded. If you have any questions throughout the webinar, please put your questions into the Q&A box at the bottom of the screen, and our speaker will try to come to the questions at the end. If you do not wish to be identified when asking your question, then please tick the anonymous box and the speaker will not identify you in their response. And just to remind you that we now have a new section on the Five Stone Buildings webinar programme for webinars only, which is where you'll be able to find the recording of this webinar and any slides used and all previous webinars. I will now hand over to Ruth Hughes.
Thanks very much, Jo. Good afternoon and welcome to this webinar on accepting foreign property. It's going to be quite a brief webinar, so if you're hoping to dash off to something else, you'll probably be able to fit it in. But I hope it's going to be an interesting one. My name is Ruth Hughes and I'm a barrister at Five Stone Buildings specialising in inheritance issues, both contentious and non-contentious, and I often deal with estates which have a foreign element, and I enjoy dealing with conflict of laws. So as Jo said, this webinar will be available afterwards for you to rewatch should you wish to, and do put questions in the Q&A box and I hopefully will be able to answer them, although I don't make any promises for the particularly difficult questions. So what I'm covering today is the acceptance of foreign property on behalf of a minor child. And this is a common problem that can occur because particularly continental legal systems have forced heirship regimes which provide for property to pass directly to children on the death of a parent, intermediated by no trust arrangement, as they aren't common in the continent. So I'm going to deal with two cases, which one is more helpful than the other in providing solutions to the problems that arise. I'm going to deal with Re Hayes and Re AC, which was a case decided last year and Penelope Reid QC in these chambers acted in relation to it on a Section 8 of the Children Act application. The other case, Re Hayes, was a decision of Master Matthews in 2015, and these issues are technically difficult under the Children Act, but they may be a bit less difficult than the sort of problems that Emma Thompson had to deal with in the film. And there are problems that can arise where the child has been left this foreign property and is resident in a different country exist because the foreign legal system might not make an arrangement for that and can't be dealt with under the local law. There are difficulties of accepting the inheritance, selling property that's been inherited, or disclaiming onerous property. So those are the sort of problems that can arise. So what happened in Re Hayes, which, as I said, was a 2015 decision of Master Matthews, as he then was? Well, it related to property in the first arrondissement, and apologies for my French pronunciation, which is going to plague the analysis of this case, I'm afraid, in Paris. And there was also a property in Nice. The father and mother of the child had been co-owners of the property, and the father had died. And under the French succession, the child had taken an interest in the property. There was an issue, the master said, that might be putting it a bit high, about whether the property was held en tontine or en indivision. So en tontine is a kind of French ownership structure which provides for succession, and it's the same root word as the English word tontine. And so I have provided a nice photograph of the Tontine Hotel, which is a pub in my village where I come from in Ironbridge. It's not the best pub in Ironbridge. I would recommend the Malt House myself if you're ever allowed to go back to pubs again. But yes, it's a hotel in Ironbridge, Tontine, but it was not, the master thought, probably held en tontine, the property in the first arrondissement, Paris, because That was very, very uncommon, he said, he thought, because he was knowledgeable, he said, about these matters for normal French people to hold property en tontine. And in any event, which you might have thought was pretty obvious, if it had passed by survivorship, there wouldn't have been any issue about the child inheriting it, because the mother would have inherited it, so it must have been held en division. But the mother said the property was in a poor condition and she wanted to sell the Parisian property. The notary in Paris wanted the authorization of the English court because there was a minor who was habitually resident in England. So there was an application that was made by the mother as litigation friend for the child in the Chancery Division. But there were problems. The first problem that the master identified was that a minor cannot contract for the sale of properties. This is an old English rule. He noted that there were differences between the way in which property rights are conceived of in France and England. He noted that immovable property in France was dealt with in a way common under Roman and law civils that have inspired the Roman system, which has inspired most civil law systems, the Dominion, a physical approach, he said, which is why we have a nice picture of Olivia Newton-John. Let's get physical. And he compared this with the English immovable property estates and interests in land, which he said was more metaphysical. So we have René Descartes, who probably wasn't thinking about section 1.6 of the Law of Property Act 1925 when he said he thought, therefore he was. But that section says that a minor cannot be the legal owner of land and has to hold it through a trust, which is why these problems don't arise in English law, because the trustees sell the property, they hold the legal title to the land, and behind that, hidden from the legal title, are the English minor's beneficial interests. So it is a very different way of resolving the problems and dealing with the land. The master was asked to make an order under the Children Act, but he claimed that he lacked knowledge in relation to the Children Act, and he didn't think that it was a good approach, and he refused to transfer to the Family Division. It's notable that he seemed much more interested in finding out about the French law than about the English law that he could actually make an order under in a different division. That was a bit surprising. He did say that he couldn't make an English vesting order under section 53 of the Trustee Act 1925. This was because it could only do so, the court could only do so if a minor was beneficially entitled to the property, and that didn't make sense under the French ownership structure because the child wasn't just beneficially entitled, and it just didn't make sense. He also didn't think that he could make an order in respect of immovable property in France, and that I'm not surprised by. And he also said that section 53 of vesting order wouldn't extend to authorizing a sale. And here we have actually the core of the problem, which is that the French system will make a decision on behalf of the minor, but won't make a decision on behalf of an English minor because they're English, and the English system doesn't want to make a decision on behalf of the minor because they're a minor and thinks the property shouldn't be held by minors. So that's where the conflict traction comes in. And the judge dealt with it finally in this way. He noted that the juge des Tuiles under the French system could authorize a child's parents to sell a property. He found that he was able to get French advice, which was from an advocate, and he did his own translation of the French code to work out what he thought the French law was. He said that the English judge could perform the same functions as the French judge, and that he would authorize the sale because it was in the child's best interests. So the case was helpful in the particular case, but it has been very significantly discouraging of other applications in similar circumstances to the Chancery Division, and it is a problem. So the decision in Re Hayes was considered recently by Mr. Justice Peel, sitting as a judge of the Family Court, within a similar but not precisely the same case. In this case, at REAC, there was a mother and a father who had owned Italian immovable property in equal shares. Unfortunately, the judgment doesn't say where, so I can't put a nice picture up. On the death of the father, half went to the child. The mother wanted to accept that inheritance on behalf of the child. She wasn't asking for an order for sale. She was asking for something less than that, just to put the property in the child's name. The child was habitually resident in England and was a minor. The judge in the AC case decided that the English court had jurisdiction on matters concerning parental responsibility under Article 8 of the European Council Regulation 2201 of 2003. That Section 3.1 of the Children Act 1989 defined parental responsibility widely, and that definition had to be purposely construed. And this included all the rights, duties, powers, responsibility, and authority by law a parent had in relation to the child or the child's property. The mother had responsibility under Section 3.1 of the Children Act to act in the child's interests in relation to the property to which the child was entitled, including the foreign property, and although the mother could not receive the property in her own name, she could take steps to make sure it was received by the child in the child's own name. The court said that this was although it was similar, the case was distinguishable from Hayes because that case was in relation to a sale. This case was just an acceptance, and it was clear that the acceptance of the property wouldn't involve a disposal of the property, and that the mother might in time want to make an application for the disposal of the property, but the acceptance of the property and putting it in the child's name in Italy was something that was clearly in the child's best interests and could be authorised under the Children Act. If the mother wanted to make an application for sale, then the decision in Hayes would need to be revisited because it would amount to the disposal of a property. However, the court gave strong indications that parties should not be dissuaded from making applications of the type that was made in REAC and in Hayes, and that they ought to be made under the Children Act, and they should be made in the family court and not in the Chancery Division. So it's likely that there will be more claims like this in the future, and that they will be decided by family division judges through the prism of Children Act parental responsibility, rather than in the Chancery Division. And this may be pragmatically helpful because it may well be that the family division judges are more centred on the children's best interests rather than the technicalities of the difference in property law between the two jurisdictions, and will be more inclined to do something that is plainly for the benefit of the child and find a creative legal solution if that's what's necessary, because it's obviously unlikely to be helpful to anybody, and in particular the child, if there's a conflict of laws black hole that these cases fall into, preventing anyone from doing anything useful with the property or anything at all with it. So I think there will need to be more cases on sale, although I rather suspect that the court would authorise a sale. I think it'd be very interesting to see what happens if a case in relation to onerous property comes before the courts, because sometimes it's going to be, the child's going to want to disclaim property that has obligations attached to it, which is something that the court might find more difficult. But I think that those are interesting issues, and I expect to see more jurisprudence in this area. So what I've done is I've had a look at the problems that can arise in relation to legal systems, particularly continental ones, where children obtain property directly through forced heirship. And we've had a look at the different ways in which the Chancery Division and Family Division have approached these problems. And we've seen that the Family Division is been more pragmatic and has directed that other claims ought to be made before it. So that's all I was intending to say on these two cases that I think are interesting. But if anybody has any questions, I'd be really interested to see what they are, and I'll see if I can now return to the screen and see if there are any questions yet. So we don't have any questions at the moment, but I'm just going to wait for a minute in case anybody else has any. I don't think there are any questions, so I just want to say thanks ever so much. Oh, someone has a question. Please put the question in the Q&A box and I'll see if I can answer it. I'm not able to let anyone else speak. Okay, well, I don't think there are going to be any live questions. So thanks ever so much for watching the webinar. And I look forward to seeing you soon sometime when the world's open a bit more. Thanks very much. Bye-bye.